Lesson 1. Company Formation and Conversion. Learning Objectives. Starting a company requires a lot of planning and activities, and more than that, there are a number of formalities which need to be complied with. Detailed procedures and paperwork are involved in order to start or to register a company. In India, Registrar of Companies appointed by the Ministry of Corporate Affairs is vested with the primary duty of registering companies. Ministry of Corporate Affairs, MCA, has started the process of filing or uploading of forms completely online, together with the attachment of required documents to the Registrar of Companies for initiating the incorporation process as a part of its MCAT 21 e-governance project. After completion of this lesson, students will be well acquainted with practical and procedural aspects of company formation and conversion, which include pre-registration requirements, name approval, acquiring digital signatures, preparation and submission of various e-forms and documents, stamping of memorandum and articles of association, payment of stamp duty, payment of registration fees, obtaining certificate of incorporation, compliance requirements relating to conversion of companies, conversion of other entities into companies, etc. Students will also be able to understand the procedural aspects relating to commencement of business and ratification of pre-incorporation contracts. Choice of form of business entity. Selection of the form of business entity is one of the most important decisions before starting a business. This decision is required to be revisited periodically as the business develops. A business entity may exercise the options for conversion and reconversion, as and when it seems appropriate. The choice amongst the various forms of business entities depends upon many aspects, such as objects of the proposed business, likely number of members, amount to be invested, scale of operations, state control, legal requirements, tax implications, advantages of one form of business over another, etc. Nature, form and types of business enterprises. Business enterprises can be broadly divided into two broad categories, namely, one which is non-corporate in form and the other which has a corporate character. Enterprises which fall in the former category are sole proprietorship, partnership and Hindu undivided family. Business organization, which comprises the latter category, are companies and cooperative undertakings. The basic difference between the corporate and the non-corporate form of organization is that while a non-corporate form of business may be started without registration, corporate bodies cannot be set up without registration under the laws which govern their functioning. Non-corporate form of business enterprises. 1. Sole proprietorship. In this form of business organization, an individual normally uses his own capital, skill and intelligence to carry out some business activity. He is entitled to receive all the profits and gains of his business and also assumes all the risk of ownership. The sole proprietor exercises full control over the affairs of his business. As there is no legal obligation to supply any information regarding his business to anyone, he can maintain maximum secrecy in conducting his business affairs. This type of organization is particularly suitable for businesses which are small in size and where risk and capital involved are not very large. 2. Joint Hindu family, Hindu undivided family. In this form of business ownership, the business is generally managed by the father or some other senior member of the family called the Karta or the manager. Karta is basically the senior-most male member of the family. The joint Hindu family firm comes into existence by the operation of Hindu law and not by any contract. 3. Partnership. In this form of organization, few like-minded persons pool up their resources to form a partnership firm. Section 4 of the Partnership Act, 1932, defines partnership as the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. This definition chiefly brings out the following features of partnership. I. Contractual relationship: since partnership arises out of agreement between persons, only those persons who are competent to contract can be partners. 2. Existence of business: there can be no partnership without business. The persons who have agreed to become partners must carry out some business activity. 3. Sharing of profits: the agreement to carry on business must be entered into, with the object of making a profit and sharing it among all the partners. 4. Mutual agency: the business must be carried on by all the partners or by any one or more of them acting for all the partners. Thus each partner is both an agent and a principal for all other partners. Partnership is an ideal form of organization for medium-scale business operations which require greater amount of capital and risks than sole proprietorship or Hindu undivided family. Corporate form of business enterprises. 1. The cooperative organization. Cooperative organization is a voluntary association with unrestricted membership and collectively owned funds, organized on democratic principle of equality by persons of moderate means and incomes, who join together to supply their needs and wants through mutual action, in which the motive of production and distribution is service rather than profit. Besides being a form of ownership, cooperative organizations are a means of protecting the interests of the relatively weaker sections of society against exploitation by big businesses operating for the maximization of profits. The basic feature which differentiates the cooperative organization from other form of business enterprises is that its primary motive is service to the members rather than making profits. A cooperative society is required to be registered under the Cooperative Societies Act, 1912. The cooperative societies receive a number of special concessions from the law and the government, in order to encourage healthy development of cooperatives. 2. Company. This type of organization is characterized by the fact that ownership and management are separate. The capital of the company is provided by a group of people called shareholders who entrust the management of the company in the hands of persons known as the board of directors. A company is an artificial legal person created by process of law which makes it an entity separate and distinct from its members who constitute it. As a natural consequence of incorporation and transferability of shares, the company has perpetual succession. Thus, it can be said that this form of organization is suitable when the capital requirements of a business are large, the liability of members is expected to be limited and the risks need to be spread among a larger number of persons. Limited Liability Partnership, LLP. LLP is an alternative business vehicle that gives the benefits of limited liability company and flexibility of a partnership firm. Since LLP contains elements of both a corporate structure as well as partnership firm structure, it is many a times termed as a hybrid of a company and a partnership. LLP is a separate legal entity which can continue its existence irrespective of changes in its partners. LLP is an incorporated partnership formed and registered under the Limited Liability Partnership Act, 2008. Owing to flexibility in its structure and operation, LLP is useful for small and medium enterprises, in general, and for the enterprises and services sector, in particular. LLP is also very suitable for professionals like company secretaries, chartered accountants, cost accountants, advocates etc., as it helps them to form multidisciplinary limited liability partnership firms. Forming a choice. Though there are some similarities between a limited company and other forms of associations, there are a great number of dissimilarities as well. In both the cases, individuals are the subjects, and pursuit of business activity is generally the object. Distinction between a limited company and a partnership firm: limited liability partnership, a Hindu joint family business and a registered society has been discussed in detail in the study of company law of Module 1 of Executive Program. Taking into account the requirement in each case and all the aspects of the various forms of business entities, the decision on the right type of business entity should be taken. Incorporation of companies. A company is an association of both natural and artificial persons incorporated under the existing law of a country. In terms of the Companies Act, 2013, a company means a company incorporated under the Companies Act, 2013, the Act, or under any of the previous company law, Section 220. In common law, a company is a legal person or legal entity separate from, and capable of surviving beyond the lives of its members. A company may be formed for any lawful purpose by a. 7 or more persons, where the company to be formed is to be a public company. b. 2 or more persons, where the company to be formed is to be a private company, or c. 1 person, where the company to be formed is to be one person company, that is to say, a private company. by subscribing their names or his name to a memorandum and complying with the requirements of this Act in respect of registration. Section 3.1. Thus, Section 3.1 stipulates the existence of the following ingredients for the incorporation of a company. I. Lawful purpose for which they should associate themselves. 2. Promoters of the company, at least 7 in the case of a public company, at least 2 in the case of a private company, and 1 in case of one-person company. 3. Promoters must subscribe their names to the Memorandum of Association of the company. 4. Promoters must comply with the requirements of the Companies Act, 2013 in respect of registration of the company. The minimum paid-up capital must be Rs1 lakh in case of a private company and Rs5 lakh in case of a public company. Section 11(1)(a). Registrar of Companies, ROC, appointed under Section 396 of the Companies Act, 2013 by the Ministry of Corporate Affairs, MCA, is vested with the primary duty of registering companies and of ensuring that such companies comply with the statutory requirements of the Act. A company shall be registered with the ROC of the state under whose jurisdiction the proposed company's registered office will be situated. Promoters to take steps for formation of the company. Promoters are the persons who conceive the idea or visualize a project and then take steps to transform the idea into a reality. They convey their idea to friends, relatives, or business associates, make arrangements for collecting equity and loan capital for the company, prepare a team of persons who would act as its directors, and take all other steps for compliance with the requirements of the Companies Act, 2013 in respect of registration of the company. Promotion is a term of wide import denoting the preliminary steps taken for the purpose of registration and flotation of the company. The persons who assume the task of promotion are called promoters. A promoter may be an individual, association, partner, or company. According to Section 269 of the Companies Act, 2013, promoter means a person a. who has been named as such in a prospectus or is identified by the company in the annual return referred to in Section 92, or b. who has control over the affairs of the company, directly or indirectly, whether as a shareholder, director, or otherwise, or c. in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. According to the proviso to this definition, a person who is acting to advise, direct, or instruct merely in a professional capacity is not a promoter. Procedure for incorporation of public limited company having share capital. The following procedural steps are required to be taken by the promoters for the incorporation of a public limited company. 1. Obtain Director Identification Number, DIN. It is important to note that every person who is to be appointed as a director must have Director's Identification Number, DIN, Section 152(3). If the proposed director does not already have a DIN, he or she must obtain the same before incorporation of the company. This can be obtained by making an application on the MCA portal in Form DIR 3. 2. Acquire Digital Signature Certificate, DSC. The Information Technology Act, 2000 provides for use of digital signatures on the documents submitted in electronic form in order to ensure the security and authenticity of the documents filed electronically. This is the only secure and authentic way that a document can be submitted electronically. As such, all filings done by the companies under MCA 21 e-governance program are required to be filed with the use of digital signatures by the person authorized to sign the documents. Acquire DSC, a licensed certifying authority, CA, issues the digital signature. Certifying authority, CA, means a person who has been granted a license to issue a digital signature certificate under Section 24 of the Indian Information Technology Act, 2000. Register DSC, roll check for Indian companies is to be implemented in the MCA application. Roll check can be performed only after the signatories have registered their digital signature certificates, DSC, with MCA. 3. Proposing the name of the company and ascertaining its availability from the ROC. promoters may to propose up to 6 names in order of procedure for the proposed company and secure the name availability by making an application to the Registrar of Companies of the state in which they want to have the proposed company incorporated. The application is required to be made in Form Incorporated-1. While applying for a name in the Form Incorporated-1, using Digital Signature Certificate, DSC, the applicant shall be required to verify that he is a promoter, proposed first subscriber to the MO, and is authorized by the other proposed first subscribers to sign and submit the application. 2. He has gone through the provisions of Companies Act, 2013, the rules thereunder and prescribed guidelines framed thereunder in respect of reservation of name, understood the meaning thereof. 3. He has used the search facilities available on the portal of the Ministry of Corporate Affairs, MCA, that is, www.mcat.gov.in web link for checking the resemblance of the proposed names with the companies and limited liability partnerships, LLPs, respectively already registered or the names already approved. He has also used the search facility for checking the resemblances of the proposed names with registered or applied trademarks. 4. The proposed names are not in violation of the provisions of Emblems and Names, Prevention of Improper Use, Act, 1950 as amended from time to time. V. The proposed name is not offensive to any section of people, for example, proposed name does not contain profanity or words or phrases that are generally considered a slur against an ethnic group, religion, gender or heredity. 5. The proposed names is not such that its use by the company will constitute an offense under any law for the time being in force. 7. He has complied with all the mandated requirements of the respective act, regulator, such as IRTA, RBI, SEBI, MCA etc. applicable only in case proposed name includes words like insurance, bank, stock exchange, venture capital, asset management, NIE, mutual fund, finance, investment, leasing, hire purchase etc. or any combination thereof. 8. To the best of his knowledge and belief, the information given in the application and its attachments is correct and complete, and nothing relevant to this form has been suppressed. 9. He undertakes to be fully responsible for the consequences, in case the name is subsequently found to be in contravention of Section 4 of the Act, rules made thereunder and the prescribed guidelines. Following documents have to be attached to incorporated. 1. Copy of board resolution of the existing company or foreign holding company as a proof of no objection. 2. Copy of direction from central government, if name is changed due to direction received from the central government. 3. Trademark or authorization to use trademark, if the name of the company is based on trademark or application for deed of assignment or a copy of application of registered trademark. 4. In case the proposed name contains such word or expression for which the approval of central government is required, a copy of central government's approval. V. Proof of relation. 5. In principle approval from the concerned regulator wherever is applicable. 7. NOC from sole proprietor/partners/other associates. 8. NOC from existing company. 9. Copy of affidavit in case of proposed name includes phrase electoral trust. X. Resolution of unregistered companies in case of Chapter 21, Part I, Companies. 11. Order of competent authority. 12. NOC as required in Rule 8.4. The name, if made available to the applicant, shall be reserved for 60 days from the date of approval. If the proposed company has not been incorporated within such period, the name shall be lapsed and will be available for other applicants. Where after reservation of name, it is found that name was applied by furnishing wrong or incorrect information, then a. If the company has not been incorporated, the reserved name shall be cancelled and the person making application shall be liable to a penalty which may extend to 1 lakh rupees. B. If the company has been incorporated, the registrar may, after giving the company an opportunity of being heard, either direct the company to change its name within a period of 3 months, after passing an ordinary resolution. 2. take action for striking off the name of the company from the Register of Companies, or 3. Make a petition for winding up of the company. Section 4.5. Rule 8 of the Companies, Incorporation, Rules 2014 contain provisions relating to undesirable names, and Rules 9 has provisions relating to reservation of name. 4. Drafting and printing of Memorandum and Articles of Association. After ascertaining name availability from the Registrar of Companies, steps should be taken to get the Memorandum and Articles of Association for the proposed company drafted and printed. The Memorandum of a Company limited by shares shall be in Tables A and Schedule I of the Companies Act, 2013. A public company limited by shares may adopt all or any of the regulations contained in Model Articles of Association registered along with its Memorandum of Association. The Model Articles of a Company shall be in Tables F and Schedule I of the Companies Act, 2013 as may be applicable to the company. A company may adopt all or any of the regulations contained in the Model Articles applicable to such company. The Memorandum and Articles shall be in conformity with the provisions of Section 4 and 5 of the Companies Act 2013. If the promoters plan to get the securities of the proposed company listed with one or more designated stock exchanges, it is advisable to send the draft of the Memorandum and Articles of Association to those stock exchanges for their scrutiny and suggestion to the effect whether they would like to have certain articles incorporated therein in compliance with the provisions of the listing agreements of the stock exchanges. 5. Stamping and signing of Memorandum and Articles. The Memorandum and Articles should be printed and signed by subscribers. Thereafter, the Memorandum and the Articles should be stamped by the appropriate state authority, collector of stamps, under the Indian Stamp Act, 1899. However, presently there is a facility for online payment of stamp duty along with filing fees. It is pertinent to note the stamping is a subject matter of state revenue and not a matter of the central government. Hence the stamp duty payable on the Memorandum and or the Articles of Association shall be determined according to the place of incorporation of the company. Memorandum and Articles of Association of the company shall be signed by each subscriber to the memorandum, who shall add his name, address, description and occupation, if any, in the presence of at least one witness who shall attest the signature and shall likewise sign and add his name, address, description and occupation, if any. The witness shall state that I witness to subscriber/subscribers who have subscribed and signed in my presence, date and place to be given. Further, I have verified their ID for their identification and satisfied myself of his/her/their identification particulars as filled in. 6. Dating of Memorandum and Articles of Association. The Memorandum and Articles are then dated, but the date must be the date of stamping or later than the date of their stamping and not, in any event, a date prior to the date of their stamping. 7. Filing of documents and forms for registration. According to Section 7 of the Companies Act, 2013, all document related to incorporation shall be filed before the registrar, in whose jurisdiction registered office of a company is proposed to be situated. A registrar may have jurisdiction over several states or only a part of a state. Following documents are to be submitted. A. The Memorandum and Articles of the company duly signed by all subscribers. B. A declaration by A. An advocate or practicing professional, CA, CS, CA, who is engaged in incorporation, and B. A person named in director as director, manager or secretary. That all requirements related to incorporation has been complied with. C. An affidavit from each subscriber and from each person named as first director in the articles that A. He is not convicted of any offense in connection with promotion, formation or management of any company. B. He has not been found guilty of any fraud or misfeasance or of any breach of duty to any company during preceding 5 years, and C. All the documents filed with the registrar contain correct, complete and true information to the best of his knowledge and belief. D. The address for correspondence till its registered office is established. E. the particulars of every subscribers along with proof of identity. F. The particulars of first directors along with proof of identity, and the particulars of interests of first directors in other firms or bodies corporate along with their consent to act as directors. Forms. I. Form Incorporated. 7. Application for incorporation of a company pursuant to Section 7(1) of the Companies Act, 2013 and Rule 12 of the Companies, Incorporation, Rules 2014 containing the 1. Service request number of Form Incorporated 1, 2. Name of the company, 3. Type of the company, 4. Status of company, 5. Category of company, 6. License number in case of Section 8 company, 7. Share capital of company, 8. Name of state in the company is to registered, 9. Name of office of the registrar in which the company is to be registered, 10. Provisional address for correspondence, 11. Share capital, 12. Maximum number of members, 13. Main division of industrial activity, 14. Approval from sector regulator, if any, 15. Details of promoters, 16. Entrenchment, if any, 17. Details of subscribers, and 19. Particulars of stamp duty, along with a declaration by a promoter and certificate by practicing professional. Documents. Following documents are required to be filled along with these forms. I. Memorandum of Association. 2. Articles of Association. 3. Declaration in Form Incorporated, 8 by an advocate or practicing CA/CS/CWA. 4. Affidavit in Form Incorporated, 9 from the subscribers to the memorandum and from persons named as first directors if any. V. Proof of residential address. 5. Specimen signature in Form Incorporated 10. 7. Proof of identity. 8. Entrenched Articles of Association. 9. Copy of in principle approval granted by sectorial regulator if already taken. X. NOC in case there is change in the promoters, first subscribers to Memorandum of Association. 11. Proof of nationality, in case the subscriber is a foreign national. 12. PAN card, in case of Indian national. 13. Copy of Certificate of Incorporation of the foreign body corporate and registered office address. 14. Copy of Resolution, consent by all the partners or board resolution authorizing to subscribe to MO. 8. Registration and filing fee. Promoters must make sure to remit to the registrar, along with the above forms/documents, the prescribed registration fee and fee for filing of forms as per the rates contained in the rules. The fee payable for the purpose can be remitted either electronically, by using a credit card or by electronic bank transfer, or by cash, draft through challenge generated electronically on submission of the e-form. 9. Minimum paid-up capital. Ensure that for a public limited company, the minimum paid-up capital is 5 lakh rupees or such higher paid-up capital as may be prescribed. 10. Scrutiny of documents and forms by registrar. On receipt of the aforementioned documents, the Office of the Registrar of Companies will scrutinize them, and if they are found complete in all respects, the registrar will register the company and generate a SIN. If the registrar finds any defect or deficiency in any of the documents or forms, the registrar will send an electronic communication pointing out the defects, and after the deficiencies are removed, the registrar will register the company. 11. Issue of Certificate of Incorporation by Registrar. After the registration of the company, the registrar will issue under his hand and seal of his office, the certificate of incorporation in the name of the company and send it electronically. One may also take printout of the certificate of incorporation generated online. The date mentioned by the registrar in the certificate of incorporation shall be the date of incorporation of the company, on which date the company will be considered to have come into existence as a legal entity separate from its subscribers. The certificate of incorporation shall be in from Incorporated, 11 of the Companies, Incorporation, Rules, 2014. 12. Certificate of Commencement of Business. On registration, A company cannot commence business or exercise any borrowing powers until it files a declaration by Directors in Form Incorporated, 21 to the effect that every subscriber to the memorandum has paid the value of the shares agreed to be taken by them as specified in Section 11(1)(a). This form has to be verified by practicing CA/CS/CWA. In the case of a company requiring registration from sectoral regulators such as Reserve Bank of India, Securities and Exchange Board of India etc., the approval from such regulator shall be required. Verification of registered office. The company has filed with the registrar a verification of its registered office within a period of 30 days of its incorporation in Form Incorporated 22. Let us remember, if the company fails to furnish such declaration of commencement of business within a period of 180 days from the date of incorporation, then the registrar can strike off the name from the Register of Companies. Procedure for incorporation of private limited company having share capital. The procedure for the incorporation of a private limited company is similar to that of a public limited company, as discussed above, with the following exceptions. I. The company must have a minimum paid-up capital of 1 lakh rupees or such higher paid-up capital as may be prescribed. 2. There must be at least 2 subscribers in place of 7, however in case of one-person company there will be only 1 subscriber. 3. Prohibit any invitation to the public to subscribe for any security of the company in its article of association of the company. 4. There must be at least 2 directors in place of 3. V. Registration of the Articles of Association is compulsory. Procedure for incorporation of Company Limited by Guarantee. Company Limited by Guarantee means a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up, Section 221. Key ingredients are: liability of its members limited by the memorandum to such amount as members respectively undertake to contribute to the assets of the company in event of its being wound up. The contribution from members are postponed to the event called winding up. The procedure for incorporation of a company limited by guarantee is similar to the one required to be followed for getting a public or a private limited company incorporated. However, the following distinctive features in the case of a company limited by guarantee must be noted. I. A company limited by guarantee may or may not have a share capital. 2. A company limited by guarantee may be a public company or a private company. In the case of a company limited by guarantee, the memorandum shall state the amount up to which each member undertakes to contribute. A. To the assets of the company in the event of its being wound up while he is a member or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and B. To the costs, charges and expenses of winding up and for adjustment of the rights of the contributories among themselves. Section 41D. 2. Any provision in the memorandum or articles, in the case of a company limited by guarantee and not having a share capital, purporting to give any person a right to participate in the divisible profits of the company otherwise than as a member, shall be void. Section 47, and Section 1311. The following procedural steps are required to be taken for getting a company limited by guarantee registered. 1. Paid up capital. In case company to be formed is a private company, it must have a paid up capital of 1 lakh rupees, and in case the company to be formed is a public company, it must have a paid up capital of 5 lakh rupees or such higher paid up capital as may be prescribed. However, if the company does not propose to have a share capital, then this requirement is not required to be complied with. 2. Selection of name of the company and ascertaining its availability from ROC. This is same as in case of public company limited by share. 3. Drafting and printing of memorandum and articles of association. On receipt of name availability from the registrar of companies, get the memorandum and articles of association of the proposed company drafted by a competent professional. The memorandum of association of a company limited by guarantee and not having a share capital shall be in accordance with Table B of Schedule I. The memorandum of association of a company limited by guarantee and having a share capital shall be in accordance with Table C of Schedule I. The articles of association of a company limited by guarantee and having share capital shall be in accordance with Table G of Schedule I. The articles of association of a company limited by guarantee and not having share capital shall be in accordance with Table H of Schedule I. 4. Stamping and signing of memorandum and articles, this is same as in case of public company limited by share. 5. Dating of memorandum and articles, thereafter the memorandum and articles will be dated. This date must be the date of stamping or later than the date of the stamping and not, in any event, a date prior to the date of the stamping. 6. Filing of forms and documents with registrar, this is same as in case of public company limited by share. 7. Registration and filing fee, this is same as in case of public company limited by share. 8. Scrutiny of forms and documents by registrar, on receipt of the aforementioned documents and forms. The Office of the Registrar of Companies will scrutinize them, and if they are found complete in all respects, the Registrar will register the company and allot SIN. If the Registrar finds any defect or deficiency in any of the documents or forms, he shall send an electronic communication pointing out the defects, and after the deficiencies are removed, the Registrar will register the company. 9. Issue of Certificate of Incorporation by Registrar. A certificate of incorporation will be issued by the Registrar of Companies under his hand and seal of his office and sent electronically. One may take printout of certificate of incorporation which is generated online. The date mentioned by the Registrar in the certificate of incorporation shall be the date of incorporation of the company, on which date the company will be considered to have come into existence as a legal entity independent of its members. One-person company. Section 262 of the Companies Act, 2013 define one-person company as a company which has only one person as member. OPC is a subdomain of private company as per Section 268. Rule 3 of the Companies, Incorporation, Rules 2014 say, only a natural person who is an Indian citizen and resident in India: